Hi, good afternoon, everyone. It is now 2 p.m. and we are ready to begin our webinar. Again, good afternoon, everyone, and thank you so much for joining our webinar titled How to Complete Section 3 of the I-9 form. We know that everyone on the call today is extremely busy, and we certainly appreciate your participation in this call. My name is Melissa Prentice, and I am the Director of Sales and Marketing here at I-9 Advantage. I am absolutely delighted to be on this webinar with you today for the next hour. At I-9 Advantage, we are extremely pleased to introduce Attorney Rebecca Mancini. She'll be our key presenter on this afternoon's call. And Rebecca is currently an immigration attorney with the Miller Canfield law firm. At the start of Rebecca's presentation, she will give a brief introduction of her background and tell you more about who she is prior to proceeding into the webinar. At this time, I'd like to turn it over to Rebecca to start the presentation.
Good afternoon, everybody, and thank you so much for joining. Thank you, Melissa, for the introduction. My name is Rebecca Mancini, and I'm a senior attorney at Miller Canfield based out of Detroit, Michigan. Though Detroit serves as our headquarters for Miller Canfield, we are a full-service international law firm with locations throughout the United States and worldwide. My practice focuses on corporate-based immigration law. Specifically, we prepare and submit employment-based temporary non-immigrant visas, permanent immigrant visas, related family matters, facilitate the global mobility of workforces around the world for employers, and we also assist with due diligence and compliance considerations, which is going to be the focus of our conversation today. For our agenda today, I'll discuss a brief review of the purpose of Form I-9 and the importance of compliance. We'll also discuss the process for completing Section 3 of the Form I-9 for rehires, and then how and when to re-verify employees, before finally touching on how to handle legal name changes as it relates to Section 3 of the I-9, before Melissa will review some solutions to help ensure and achieve that employers are compliant with Form I-9 regulations. And last, Melissa and I will reserve some time for all of your questions. Form I-9 is used to verify the identity and employment authorization for individuals hired for employment in the United States. As all U.S. employers must ensure proper completion of the Form I-9 for all new hires after November 6th of 1986, it's quite important for employers and representatives of these employers to understand the requirements for compliance, particularly in this case as it relates to re-verification and completing Section 3. Now, both non-citizens and citizens are included. When we refer to all hires, we truly mean all people that are working for U.S. employers in the United States. It's important that employers verify the identity and employment authorization, and we do so through completing the Form I-9, which is in 3 sections. Section 1, as you all may be very well aware, is completed by the employee with their personal information and an attestation that that information is truthful. Section 2 is completed by the employer, where the employer will review and verify documents that are provided to establish their identity and work authorization in the United States. Section 3, which is the main focus of our discussion today, is not always completed, but when necessary, would be completed by an employer for employees who are rehired or whose employment authorization requires verification. One note is it's important to refrain from discriminating against individuals on the basis of actual or perceived national origin, citizenship, or national or immigration status. Form I-9 requirements state that employers must comply with all federal regulations relating to completing, maintaining, and updating Form I-9 and its various requirements. It's of utmost importance that all U.S. employers ensure that they have a Form I-9 on file for all current employees. The easiest way to do this is to match a printout of your current payroll up with an I-9 record for each individual that you have working there. And where somebody does not have an I-9, it's important to complete an I-9 for them immediately upon discovering this, and in doing so to ensure that you use the most current version of the Form I-9, which is with a revision date currently as of today of November 14th, 2016, and it states N. It's actually, it has the date on the bottom left of the current I-9 that says 11-14-2016N. The exception would be if you do happen to have employees on payroll who were hired on or before November 6th of 1986, which may be the case for some of you. In that situation, you would not be required to have a Form I-9 on hand for that employee. Employers don't always have to be the one that completes the employer sections of the I-9. You may have a delegated authorized representative to assist you with completion of this. This typically includes somebody in a personnel officer role. Notary publics occasionally can assist with this, and it comes up primarily in the context of remote hires or in a large workforce where you have employees located at various different work sites. It is important to remember that even if the employer doesn't complete the employer sections of the I-9, they will still ultimately remain liable for any errors or violations. On the left side of your screen, you'll see Section 3 of the I-9. As mentioned before, this is the focus of our presentation today. So Sections 1 and 2 are on the prior 2 pages, and Section 3 is often unused until, of course, you come up to needing going through and using this. So that brings us to our first question. When do we use Section 3? It's used when an employee's employment authorization or documents that previously established employment authorization have expired. Section 3 may be completed by an employer if your employee is rehired within 3 years of the date the original I-9 was completed, or if your employee has a legal name change. Now, does every employer complete a new I-9 when an employee is rehired? It depends. You may do so for complete a new I-9 for all rehires, or you can choose to use Section 3. It is important to keep it consistent, as is all of your I-9 practices within the company. So the company should decide whether they're using paper or electronic I-9s. They should decide whether they are retaining copies of identity and work authorization documents that are provided for all employees or none. And similarly, whether you complete a new I-9 or you use Section 3, that would need to be consistent per your company practices as well. Reverification is the process of accepting new and updated documents, reviewing them for their validity, and completing Section 3. One important point to note is that employers must ensure that the newest version of the Form I-9 is used if Section 3 is required to be completed. So that may involve using a new version of the form and stapling it to the originally created form. It's also important to keep in mind that if it was more than 3 years ago when the original I-9 was created, you must do a new I-9. How do I rehire an employee if my company participates in E-Verify? Many of you on the line may participate in E-Verify, which is the USCIS program for confirming employment authorization inside the United States. As those of you who use the program know, all new hires must have to have a case created within the E-Verify system. So if you're discussing whether you have to run through a new case when you rehire an employee, the E-Verify case status will prompt the employer to update or re-verify in Section 3 or complete a new I-9, but a new case should not be created in E-Verify for these individuals. We're going to touch a little bit more in depth on the process of name change in the future, but just very briefly, the employer is not required to do a new I-9, but we do recommend that accurate information is maintained for all employees, so you may do so, but again, we'll touch on that in just a couple of slides. Should employers use Section 3 for temporary extensions? In cases where there are automatic extensions of work authorizations that have been granted, or a temporary receipt notice has been provided indicating that an extension has been requested for such temporary work authorization, Section 3 should not be used. In lieu of completing Section 3 in these situations, the employer completing the update for such receipt notices or temporary extensions should write in the margin in Section 2 where the prior approved work authorization period was indicated, and write the type of automatic extension that's being granted or the receipt number with the receipt date. For example, if you employ H-1B or L-1 or other non-immigrant classifications that automatically grant a 240-day extension for timely filed extensions of their current status, the employer would simply write 240-day extension or some other legally permissible or identifiable shorthand note in the margin on Section 2, perhaps with a receipt number to indicate the new date by which the 240-day extension would expire, and the new document evidencing employment authorization would need to be provided. There are other such circumstances where that time period may be 180 days, for example, for an employment authorization document automatic extension if they are eligible. The same process would be in play. You would need to write that in the margin on Section 2 and then refrain from completing Section 3 in these cases. The new expiration date, which is set by the temporary extension, for example, 240 or 180 days, would be the date by which the employee has to then provide updated actual employment authorization by presenting a new acceptable document from the list of documents for I-9 purposes. And then at that point, the employer would complete Section 3 for re-verification by providing that new document. The last question on our slide here is, how do I determine if there was a reasonable expectation of employment at all times? These may be situations where it seems as though you have a rehire situation, or maybe even in a Section 3 completion situation, but where USCIS defines continuing employment as a situation where hire has not taken place because the employee is continuing in their employment and has a reasonable expectation of employment at all times. This is not a black and white test, but some examples of continuous employment include pre-approved paid or unpaid leave, such as maternity leave or another type of short-term disability leave, reinstatement following a temporary suspension. Another example of reasonable expectation at all times would be seasonal work. You're employed as a regular employee with on a substantive basis, as others would be in that role. It just happens to be not on a continuous basis. Or there is reason to believe that the communication between the employee and the employer evidences that they do have a job at all times when they're available to work. If it is not defined as continuous employment or reasonable expectation of hire at all times, then a hire would be considered to have taken place. And if that hire has been considered to be taken place within 3 years of the initial I-9, you would go back and follow the Rehires procedure for completing Section 3. And if it's happening later than 3 years, you would need to complete a new I-9. It's always important to distinguish the slight differences that take place whether you're an employer that participates in E-Verify or you're an employer that does not participate in E-Verify and is held to strictly the Form I-9 regulations. So first, on the left-hand side in the purple column, if you rehire an employee within 3 years of the date that the Form I-9 was originally completed, you may either rely on the information on the previously completed Form I-9 and choose only to complete Section 3 of the most recent version of the I-9, or you can complete a new Form I-9 for the employee. And then if you're using E-Verify in the system, you'd follow the prompts to update and re-verify Section 3 for that individual hire. If you rehire an employee after 3 years of the date that the Form I-9 was originally completed, then both a new Form I-9 must be completed and a new case should be created in the E-Verify system. On the right-hand side, for rehires at employers that are not using E-Verify, if you rehire an employee within 3 years of the date that the Form I-9 was originally completed, you may either rely on the information on the previously completed Form I-9 and only complete Section 3, or complete a new Form I-9 for the employee. As we previously mentioned, it's of utmost importance to decide how the company is going to do this and to stick with that consistently throughout the practice. If you rehire an employee after 3 years of the date that the Form I-9 was originally completed, then a new Form I-9 must be completed. As we mentioned before, reverification is the process of reviewing documents to determine whether their identity and work authorization is valid for purposes of the sections of the document. Just a few short bullet points on what to remember when you're re-verifying. You should re-verify work authorization on or before the date the document expires. We recommend notifying an employee at 90 days out before their work authorization document that they provided that they're currently working on is set to expire. Using a software system such as I-9 Advantage is a great way to receive reminders when to do that. It will be triggered for you. But if you're still using paper I-9 systems, then it will be up to you to set out calendar reminders for those 90 days out, or at least before the work authorization expires, to remind an employee that they're going to need to provide acceptable documents in order to continue their employment at the company. Number 2, enter only the work authorization document, not unnecessary documents. It's important to not over-document and to do that consistently. Employers should decide whether they will keep documents that are provided to prove identity and work authorization or to not keep them. And again, it should be done consistently throughout the practice of the employer. You can keep only the documents, if you decide to keep documents, you can keep only the documents that were necessary to complete the Form I-9. So not keeping 2 List A documents, not keeping 2 of each List A, B, and C, not keeping extra documents that aren't even listed on the form, the acceptable documents for Form I-9 purposes. Simply keeping the documents that you had to use that were provided by the employee for the purposes of establishing identity and work authorization is the maximum that should be kept. If they are kept, keep the copies with the I-9, and again, don't accept too many. Do not ever re-verify U.S. citizen, permanent resident, or a non-citizen national. And the permanent resident category also includes conditional residents, which are green card holders that typically have received their work authorization through marriage to a U.S. citizen, for example, and they have a card which indicates conditional, meaning they have to apply again to remove those conditions in the future. Nevertheless, if they fall into one of these categories by providing a document that establishes they are a U.S. citizen, permanent resident, or non-citizen national, those should never be re-verified, even if they list an expiration date on it. The theory is that they've been granted that status, which provides them the ability to work indefinitely, and it's not for the employer to question whether that continues beyond perhaps a date that is expiring on one of these documents. So for U.S. citizens, for example, passports do expire, but you should not re-verify. For permanent residents, like we just mentioned, green cards typically expire in 10-year increments, 2 years for conditional residents typically, and despite those dates, re-verification should never occur for these individuals. In addition, do not ever re-verify a List B document if it's been expired. List B documents, as a reminder, are those that establish identity. So those that are listed on the acceptable document list under List B should never be re-verified either when expired. And finally, just another reminder to use the correct version of the I-9. The I-9 has very recently been updated, given that November 2016 date that we're currently using. There are plans to update it again by the end of the summer or early fall if it takes place when we expect it to. So making sure that you're always checking online at the USCIS website to print off the most recent version by using a software company such as I-9 Advantage that will ensure that the newest versions are available, and not relying on a stack of previously printed ones in the office that just set you up for liability in the event you accidentally use the old one or aren't aware that the new one has become available. We wanted to go over some requirements and best practices in the event that there's a legal name change. It's important to know that the employers are not required to update the Form I-9 when an employee has a legal name change. However, we do recommend that employers maintain accurate and up-to-date information on the Form I-9. The reason for doing so is that it's on the employer to determine whether an employee is actually who they say they are, and that the work authorization documents actually do belong to that same person. Discrepancies in names between documents may call into question whether the employer has the ability to determine whether it is the same person. It could also cause confusion in the event of an audit or a change in personnel who is in charge of the I-9 practices and may come in and do an audit and review things, and they may look at the payroll and not be able to determine that the person who provided documents previously is who they say they are. However, it's very important to not require employees to present documentation that show they have changed their name. So if you hear that Jane Doe got married a couple months ago, it is not the employer's responsibility to reach out to Jane Doe and ask her, hey, you got married. Are you going to provide me new documentation to show that you updated your name to match your husband's? This is not something that the employers are legally able to do, but if somebody does come up to you, Jane Doe, for example, and indicates that they have changed their name and presents a new document to you to establish that, then you can decide as the employer whether to re-verify or to complete a new I-9 given this new information. Finally, employers should take steps to be reasonably assured of the employee's identity if there has been a legal name change, and then note the reason for that change if presented by the employee. In completing the I-9s and reviewing documents, it's of utmost importance for employers to avoid discrimination. That you should reduce your risk of liability by ensuring consistency in the practices that your company partakes in for I-9 completion, re-verification, and for maintaining documents and I-9s on record. If choosing to complete a new Form I-9 for rehires, simply be consistent and complete a new Form I-9 for all employees being hired. Don't re-verify again U.S. citizens, permanent residents, even if conditional, or non-citizen nationals. Do not use Section 3 for temporary extensions, as we talked about before. It's for Section 2 in the margin to mark where those may be occurring. And do not use unfair document practices. Employers should not demand that certain documents be provided. The list of acceptable documents should be provided with the I-9 when they're asked to complete it within 3 days of their hire or start date. They should allow the employee to provide the document or combination of documents that they have available and choose to provide. In the event that those documents are not acceptable for any of the sections, including Section 3, then the employer should simply provide the list of acceptable documents again and give them another opportunity to provide compliant documents, but should not say, no, we need a Social Security number, or we need a receipt number for a filed extension or something like that. It's always up to the employee what they provide, and employers may not practice unfair document practices by demanding certain documents be provided. Employers should also not require that proof of work authorization be provided in advance of their hire. This practice should only be done in connection with completing the Form I-9 after they have been offered the job and accepted and they're starting work. Again, the list of documents, acceptable documents, should be provided at this time and not before that. You can include language in your offer letters in order to protect the employer against hiring those who don't have valid identity or work authorization documents. But you can't demand to see that up front to make a determination in whether or not you're going to hire that individual. Employers must also not refuse to complete an I-9 or continue employment if a document that is offered up is valid to show identity or work authorization at the time of hire, even if it will expire in the near future. If it's valid at the time of hire and they can provide acceptable documents, then the employer must accept those, list the expiration date, give them an opportunity to show extended and ongoing proof of employment authorization at that time. And if they can't provide it then the employer would have to remove them from payroll and cease from employing them. But until that happens, an employer cannot unilaterally decide that because their work authorization is only good for a short period or will expire in the future, that they won't continue to hire them or employ them. And then finally, employers should not refuse to accept certain documents over others. So they can't say that we would prefer if you provide a passport, we prefer if you provide this if you have it available. It goes back to avoiding demanding certain documents. Violating the anti-discrimination provision of the INA, the Immigration and Nationality Act, during any stage of the Form I-9 process, from initially completing the Form I-9 and completing sections 1 and 2, all the way through re-verifying or rehiring, can lead to significant fines for companies of all sizes in all different industries. We've outlined some recent Form I-9 related fines for some pretty well-known companies. Although these companies tend to be larger companies, and you may recognize many of the names on here, it really is any company, any size, any time that can be liable for fines that can really add up for employers. And it's not only civil fines, which we'll go over the amounts in a second, but it's also criminal penalties for a pattern or practice of violations. You can be debarred from government programs and contracts as the employer if you are, do have a pattern or practice of violations as well. An order of back pay can also be issued against the company to owe that money to an employee, or an order of forced hire to employ that employee that they find was previously wrongly refused hire. Just to keep this in perspective, in August of 2016, increased penalties and fines were announced, and they went up significantly. So in the past year, it became even more important for employers to engage in proper and compliant I-9 and hiring practices. For reference, for knowingly employing illegal workers, the fines are now, for first-time offenders, ranging from $539 to $4,313 per violation. And for repeat offenders, it's up to $6,469 to $21,563 per violation. And this isn't only for knowingly employing illegal workers. Paperwork violations, whether they be substantive or technical, on actually completing the Form I-9 can also really add up. Since the raise went up in August of 2016, those paperwork violations range from $216 to $2,156 per infraction or error found in the event of an audit or investigation. A paperwork violation, as I mentioned, can be substantive or technical. It can be as simple as where the form requires the start date be completed as day, month, day, year, and for whatever reason the day was not completed, it was completed only month and year, that's a fine. If a middle, initial was incomplete, that's a fine. If any other portion of the documents were incomplete, then each different violation carries its own separate fine. And in the event of an audit, you'll receive a notice of intent to fine, which will outline every single one of the violations, which you'll have a chance to correct, but not all can be corrected after you're issued an audit or investigation. It's best practice to review your I-9s by conducting regular audits internally in order to avoid these fines and violations. Given that now it's twice as costly for employers since last year that aren't compliant, compliance is at an all-time high. It's necessary for employers to engage in lawful compliance for I-9 and hiring practices. We recommend that an audit is conducted at least annually within the company. That can be the person that's in charge of it, of running the I-9s. It can be hiring an outside attorney, an immigration attorney, or another attorney that specializes in this, to go through all of the I-9s and check for violations, provide an opportunity to re-verify where necessary. If a document has since expired, somebody's working without having provided the updated proof of work authorization. Complete I-9s for those who don't have any on record, and all of the changes that are made should be one strike through, initialed and dated by somebody who changed it, and all changes should be memorialized in a memorandum that is put on the top of, let's say if you're keeping the I-9s in paper format, on top of your binder where they're kept, or in some other place where would be readily available or seen by an auditor in the event of an investigation. If not happening annually, we also strongly recommend that if there's a change in the lead personnel who's in charge of overseeing the I-9s, that at that time the I-9s are reviewed. And this is because, let's say Jane Doe was previously the human resources manager for company A, and she left the company, and then John Doe took over her job. Without John going through and reviewing all of the I-9s to ensure compliance, with Jane gone, the company still remains liable for any I-9 violation. Utilizing software systems such as I-9 Advantage can be really helpful in making sure that you've just got a double check on all of the sections and the fields that need to be completed. Having timely reminders of when documents are expiring and re-verification is necessary. And to learn a little bit more about that, I'm going to pass the microphone back to Melissa, who can let you all know a little bit about how I-9 Advantage can help you to stay compliant and perhaps avoid any of these fines, penalties, and violations that we've discussed today.
Thank you so much, Rebecca. We certainly appreciate the information you've shared today with everyone on this webinar. I think it's been extremely informational and helpful to everyone as well. I-9 Advantage, as Rebecca had mentioned, is a provider of I-9 compliance software. There are actually 3 products that we provide to allow you to assist you in making sure that you are compliant and that you remain compliant. Those 3 products are I-9 Advantage, I-9 Medic, and I-9 Remote. I-9 Advantage essentially allows you to have the employee complete Section 1 of the form, either in your offices or remotely, and then an individual from within your organization will then log in and complete Section 2. Throughout the completion of Section 2, we are guiding the behavior of the individual to ensure that they're not over-documenting or under-documenting or omitting required and necessarily information, and as Rebecca said, ensuring that the manner in which the data is being input, such as the date and so on, that's all accurately performed. You can also upload and store copies of your documents in the I-9 Advantage platform. With I-9 Remote, this specifically addresses those remote hires that you are probably struggling with today. The I-9 remote platform assumes that the employee will complete Section 1 remotely, and you will utilize a third-party agent to complete Section 2 on your behalf. We do have 4 different options that are available to assist you with the completion of Section 2 of the form, which includes 12,500 notary network that will travel to meet with the employees and complete Section 2 of the forms. We also have I-9 centers strategically placed across the U.S. There are about 300 of these where the employees can go into one of those locations that are conveniently located to complete the form. We also allow for you as the employer to select or identify the agent, or for the employee to identify the agent as well, and that is on the I-9 remote platform. Our third platform is I-9 Medic, which will assist you in completing audits of the I-9s. Rebecca mentioned that you should have periodic audits performed. We do have an auditing program, an auditing option called I-9 Medic, where we'll take all of your paper forms, digitize those forms, and then put it through our auditing program to notify you of any errors on the forms, allowing you an opportunity to make corrections on those forms. Again, 100% cloud-based, mobile-enabled. All 3 products, you have Reverify integrated with remote and with the I-9 Advantage platform as well. So if there's any interest in any of these, please feel free to contact us after this call. Now, I'd like to move forward with answering and responding to questions that may have come in throughout the webinar this afternoon. And the first question I'm going to read off is, I entered the webinar a few minutes late. However, I understood it to be said that rehires are not verified through E-Verify. And then it goes on to say the following is from the USCIS website accessed a while ago. Rebecca, do you care to address that? And again, the specific question there is, I understood it to be that rehires are not re-verified through E-Verify. Can you comment on that, please?
Yes, that's correct. That's the process. So when we go back to the slide that we reviewed, we noted that the difference is that they're not re-verified on the E-Verify process. It's just that E-Verify will prompt them to update and re-verify Section 3 on the actual I-9.
Okay, great. Another question that was submitted is, and this is more of a general question, and the question is there a difference between a compliant I-9 system and an electronic I-9 system? What is the difference? And there certainly is a difference. There are many systems out there today that are electronic, which simply means it allows you to access the I-9 form via the web and complete the form and possibly sign the form via a website or via a link that is provided. That is simply an electronic I-9 form. A compliant I-9 form, such as the one that we provide, is one that looks at the rules and regulations from the USCIS and ensures compliance all the way through with e-signatures and audit trail and so much more. So if you are today utilizing an online I-9 that is not a compliant I-9, it's very easy to tell the difference. If there is no audit trail, that's one major indicator. Many of these are not e-signature compliant, and certainly something you'd want to take a look at and confirm or verify. The next question I believe we addressed on the webinar, but the question is, do I have to re-verify a form if the employee was gone for 6 months or 12 months and so on? Rebecca, do you mind addressing that again?
Sure. So if I understand the question correctly, they've asked, do I have to re-verify a form if the employee was gone for 6 months or 12 months? Is that what they said?
Correct.
So the important thing to note is that Section 3 may be completed if the rehire takes place within 3 years of the initial I-9 being completed. Then that would be a potentially rehiring procedure process. But if it's taken place later than 3 years, a new I-9 needs to be completed. So really it's more so the 3-year mark. that's important for re-verification processes. If we're talking about less number of time, then you might be in a situation where it's what we touched on. Was there a reasonable expectation of employment all times? Could this be considered a continuing employment type of a situation? USCIS outlines on their I-9 portion of their website, as well as in the employer handbook for I-9 practices, many different questions that you can walk through to determine whether this is a continuing employment situation and whether perhaps if it's within the 3-year period, you know, a rehire has taken place or not.
Okay. Okay, great. Thank you, Rebecca. Also, the next question is, can we get a copy of this presentation? And note that everyone on this call today will receive a copy. We'll send it out to you within 48 hours, so you'll have it via your email address that was provided. The next question, and Rebecca, this looks like another one for you. Can we strike the old name and write the new name on the existing I-9 if there is a name change?
So for the name change practices, they really state that you should make sure that you're either doing Section 3 or that you are completing a new I-9. You can come across situations other than legal name changes where they say that their identity is different, and that would trigger an entirely different situation and set of circumstances that you need to do. But if it's strictly just a recording of a name change, it's recommended that you note those changes in Section 3 rather than striking it out. The strikeout would be for a situation where, for whatever reason, John Doe's name was written as James Doe instead of John. And when you do an internal audit and you discover that, let's say you have a copy of their driver's license that was previously provided and somebody just incorrectly wrote their name down, then you can make the strike note and correct that. But if it's a legal name change, then that would be either a Section 3 or new I-9 trigger rather than a strikeout for correcting an error or an omission.
Great. Thank you, Rebecca. I have another question, and Rebecca, another one that's going to be coming your way. And the question is, can you expand on the McDonald's situation? How can we verify work authorization if we are unable to see the new document when renewed?
So we're talking about, sorry, I'm just flipping over here. For those of you who can't see the screen anymore, they're referring back to the recent Form I-9 related fines for McDonald's. It says that they required lawful permanent residents to show new green cards following the expiration of old ones, and the company did not make similar requests of U.S. citizens. Melissa, can you repeat the actual question for me again?
Yeah, the question is, can you expand on the McDonald's situation? How can we verify work authorization if we are unable to see the new document when renewed? So it sounds like they're unable to actually see the document and asking questions around how can they re-verify it if they're unable to see the document. I think the answer there is that they do have to meet in person to have that renewed.
No, so even if the green card, if you're hiring somebody that has a lawful permanent resident green card, it needs to be valid at the time of hire to present it, but confusing, and this is actually quite a normal mistake for employers to make, such as McDonald's did. You know, it's logical when you see an expiration date on a card and employers think, well, you know, I'm going to be proactive about this. I'm going to ask them to provide their new one. And in many cases, those green card holders do maintain a valid green card because they need it for international travel and other purposes. And so they may be re-verifying those, but it's actually illegal to do that. You're supposed to just take that whenever it was valid, and it's good for the duration of their employment as long as that employment continues. If they go to a new company for a new hire, again, it has to be valid. But once that expires, along with a U.S. passport or other documents provided by U.S. citizens that might have expiration dates like lawful permanent residence, employers may never re-verify them or require them to show new, updated, valid documents.
Great. Thanks, Rebecca. The next question is, do you need to back into E-Verify to update a case for a name change and make copies of the ID to attach to the case? So this one's E-Verify, and I'll repeat that one more time. Do you need to back into E-Verify to update a case for a name change and make copies of the ID to attach to the case?
So the question, if I have it correctly, is if they have a name change, they want to know how they handle that situation if they're using E-Verify, correct?
That's what it appears to be. That's
Okay.
correct.
So, for example, if you have somebody, that has had a legal name change, then you should enter that new last name in the last name field for the I-9 case. You can update it in there. I hope I'm answering the question correctly. Maybe they could write it. Yeah, I mean, you complete Section 3 of the I-9, you attach it with the old form. They also ask for an explanation of what has happened, but in terms of going into E-Verify, I mean, you're not required to do a new case. It's the same person, whether they have a legal name change or not. So you don't have anything to do other than the requirements for the actual Form I-9 should somebody present you with the new document to complete Section I-9 or a new I-9. You keep that, and you don't have to keep a copy of the new, let's say, driver's license or whatever document they change with their new married name or other reason for changing their legal name. You should keep that in accordance of what your normal practices are. Meaning, if you keep copies of documents, then keep it for this situation, and if you don't keep it. But you do have to maintain a written explanation of what happened. So that would just be as simple as Jane Doe got married, or John Doe simply chose to change his name to James Doe, and that's sufficient.
Okay. All right. Thanks, Rebecca. The next question is for people who have an I-94, the expiration dates renew whenever they travel outside of the U.S. Do I need to re-verify the I-9 every time they travel back and forth?
So in most cases, the I-94 expiration date is going to be tied to the validity of their work authorization in the United States. So in most cases, there's going to be, an end date of, let's say, July 1st. And no matter how many trips they take in and out of the United States, before they extend that by filing, let's say, an H-1B extension, extending their work authorization and status here, each trip shouldn't be changing that date. So once you have an I-94 date at the time of hire, let's say, and it's in the future, then you can just go off of that date. You're not expected to follow up with an individual every single time they travel and leave the country. You just need to make sure that you re-verify that person by requiring that they provide updated proof of work authorization beyond that, again, for example, July 1st date, around that time. So it's the short answer, not your responsibility to track their I-94 every time they're traveling. You can go off of that date because it should ideally be matching up with when they are work authorized through in the United States.
Okay, great. The next question is, if an employee is rehired within a year, it looks like the same question. If an existing employee who is not an I-9 Advantage yet obtained an I-20 cap gap and is awaiting for their H-1B approval, does the employer have to have this employee complete a new Form I-9 and update Section 3 when his H-1B has been approved? Should I repeat that?
Yes, please.
Okay. If an existing employee who isn't on I-9 Advantage yet, I'm not sure what that means, but has obtained an I-20 cap gap and awaiting for his H-1B approval, does the employer have to have this employee complete a new Form I-9 and update Section 3 when his H-1B has been approved?
So let's take that in two parts. If you have an employee who's been first selected in the H-1B lottery, which is going to happen anytime between April 1st and October 1st, and their F1 OPT work authorization period ends between April 1 and October 1, then once they find out they've been selected in the lottery, let's say that happens on May 1st, then they're going to get a receipt notice from USCIS. The employee, employee, yes, but the foreign student employee is automatically eligible for the cap gap extension, as you correctly note. However, they do need to take that receipt notice to their designated school official at their university, and so that their designated school official can update their SEVIS record and produce a new I-20 form evidencing their cap gap extension. And then they would be able to provide that to the company in order to use as a receipt of sorts to indicate that they have a cap gap extension, but it's not proof of updated employment authorization until their H-1B is approved, at which point when their H-1B becomes approved, October 1st start, then they can present their H-1B approval notice and whatever other combination of documents to satisfy that they have available, and that would be completed in Section 3.
Okay, great. And we have about 4 more minutes. I'll try to get through as many of these as we can, as mentioned earlier. Those that we are unable to respond to online, we will respond to via email. But the next question is, if someone's status changes from alien permanent resident, should a new I-9 be completed, or can Section 3 be used? And that's for someone who changes from alien to permanent resident. Should a new I-9 be completed, or can Section 3 be used?
So I'm not really sure what they're changing from to permanent resident. And did the question...
It says alien.
From alien to... Okay.
Yep. Mm-hmm.
So I'm assuming that we're trying to encompass any non-immigrant status, work authorization, otherwise, from that to permanent resident. If that's the case, if you're talking about somebody, for example, who held an H-1B visa or F-1 OPT, or was working based on an employment authorization card, any type of temporary work authorization that has an expiration date on it that doesn't fall under the category of the never re-verifies, so they're not a U.S. citizen, they weren't a lawful permanent resident or a non-citizen national, then yes, Section 3 would have to be completed once that individual has the green card in hand. Once they've been granted permanent resident status, then that is the basis for that becomes the basis for their work authorization in the United States. So they should be presenting you with that card once they have it, and then you would complete Section 3 or a new I-9, depending on your company's practices, to update their work authorization to that of a lawful permanent resident. And then once that is done, there would be no need to re-verify in the future.
Okay, great. Thanks, Rebecca. The next question is, if the employee marks in Section 1 that they are a permanent resident and are valid documents from list, I think it means, and the valid documents from list B and C enough to verify the status. So can list B and C documents be enough to verify someone who is listed as a permanent resident?
So they're just saying that the way that the employee has completed the form does not make sense for what they're providing for terms of the documents that are. So, I mean, this goes under, you can't tell them what they need to provide in order to prove work authorization. However, it does create a mismatch in terms of whether you should re-verify or not. If this is somebody who actually has this situation, I would recommend, if you're listening right now, to reach out to me, because it may just have been an error in the way that they completed the form, or there could be something else going on there, because it wouldn't make sense for somebody to do that unless they had other compelling circumstances. But if they list that, they check that box but don't provide a green card, then yeah, they might need to be re-verified in the future.
Great, thanks, Rebecca. And the very last question we'll be able to get to today is, if the I-94 expires and the foreign passport expires, do we need to update both, or just a new I-94 info in Section 3?
If if the combination of documents that they provided expires, and then you have to do re-verification, they would have to present a new set of valid documents for re-verification purposes. So if they're using a combination of documents, then those combination of documents have to be valid at the time that they're provided for either hire or re-verification.
Great. Thank you so much. And my apologies, we're out of time for the remaining questions. As I mentioned, we will follow up with you directly via email to respond to the remaining questions that we're able to get to. We certainly appreciate your time on the call today. Please reach out if you have any questions. And again, thank you so very much for your time, and thank you very much, Rebecca, for a great presentation this afternoon.
Thank you, everybody, for joining.
Have a great day. Bye-bye.